Good evening, this is Rahul Reddy, along with Ms. REDDY NEUMANN. We are here live to give immigration news to you as we do every week at 5 p.m. Central Time. Thank you for all of your patronage to our office, and we're getting to 10,000 likes and approximately 8,000 subscribers in the YouTube. Emily?
So this week we're going to be talking about delays that we're seeing with the I-539 processing due to the biometrics and how that's impacting H-4 EADs and L2 EADs and what are some of the possible solutions to that. We'll also talk about what we know so far about Trump's newest immigration plan, the merit-based kind of point system, what we can expect from that, and if it's actually going to be going anywhere. We'll talk about what your options are in the situation if you have not been selected in the lottery. As we know, the data entry was completed last week, so we're going to be getting the last few receipt notices over the next couple of days, and then case processing has already begun. And we're starting to see denials in some cases when there's no request for evidence issued. We know this stems from a September 11th memo from last year that came out, but we hadn't really seen any examples of them implementing that so far, and now we are starting to see that. It's not rampant or anything like that. It is in limited cases, but we just want to make you aware that that is happening. So we'll talk about that. And of course, as usual, we'll answer your questions. If for some reason we're not able to get to your question, you can always call into our daily conference call. And if you want more detailed discussion, you can go to rnlawgroup.com and set up a consultation with either of us or any of our team members. I'd be happy to help.
Emily, on the H-4 EAD, this has been a hot topic now. On March 11th, USCIS came up saying that for all the 539s, the people have to do fingerprints. So when they're doing fingerprints, it's taking a longer time. And we used to file H1, H4, and EAD together, and we used to get the H1, H4, and EAD approved on the same day, which is processed in the premium processing. Now, since the fingerprint process came in, we have not seen a single H4 approval as of now. The cases that we have filed in on or after March 11th, not a single. Now I'm looking at, and when we did contact the USCIS in both service center, in California and Nebraska service center, they said that they're not going to adjudicate the cases in premium processing. The H4, they are not going to do it. In other words, it takes a long time for them to get the H4 adjudicated. Until the H4 is adjudicated, the EAD is not going to be adjudicated. Mm-hmm. So in these cases, now, the Vermont Service Center, particularly, I was just checking the timing, is between 10 months to 13 months timing right now for the Vermont Service Center to approve. In other words, if the H-4 EAD is expiring, as you know that they cannot work once the H-4 EAD is expired, they may have to wait for approximately 10 to 13 months or even longer period of time. Is there a solution that you have for these people?
Well, our first option that we're looking at to try to kind of avoid the delay is maybe not filing in premium processing initially, and then after we know the biometrics have been taken care of and received by USCIS, upgrading to premium processing at that time. We're in the process of testing this out, so I don't have any real-world results of that option yet, and we'll definitely keep you posted on how that's working. But for those that are stuck waiting, and the EAD specifically is based on the processing time of the H-4. So until the H-4 gets approved, the EAD can't be approved. So if we're continuing to see these long processing times where USCIS is not going to process them in premium or with any kind of priority, even though they were filed with a premium H-1B, I think litigation is going to be our next step. Under the Administrative Procedure Act, the government, specifically DHS, is supposed to finish cases in a timely manner. Congress actually set out timelines for when they should be finishing immigration benefit applications, anywhere from 30 to 180 days. So if they're taking more than 30 days to adjudicate a simple H-4, which is probably one of the easiest things to adjudicate, I think there's a very good case for filing a delay action in court And it takes some time to get all of that together, but once you file, you should have some answer within 60 days, typically is what we're seeing. So that is definitely something to consider.
You're telling that, H-4 EADs, these are normal people working in normal software professions. They don't want to go against the government. Is there any fear for retribution for the government if you file a litigation in the court?
No, definitely not. I mean, you're right. As someone in the United States who's seeking to use the services of the agency, you're allowed to receive those benefits, and you.
Well, I understand that. Okay, you said there is no retribution. That it's not a dictatorial country where retribution will happen just because you exercised your legal right in filing a case in the United States. What about the cost? Is it going to cost like $20,000 to file a H-4 EAD delay litigation, or that's going to be too much for the people to bear the burden?
Yeah, it's definitely not anything at that level. Now, litigation can be expensive, and there are certainly some types of court cases that do cost that and a lot more. But this type of litigation we're talking about is something that can be reasonably affordable for most high-skilled worker clients.
So, what is your law firm doing, Emily, to cut down the cost for the H-4 EADs so that they can go, because the solution doesn't look to be that they're going to get a H-1B, H-4 and EAD approved, and unless they want to wait for 13 or even longer time to get their H-4 EAD approved, in the interim period they are to be unemployed. What is your firm doing to reduce the cost for these people?
Yeah, one thing that we're looking at is the idea of combining several plaintiffs together in one lawsuit. So that way we're making the same arguments for multiple individuals who are similarly situated, filing one case all together, and that should cut down on the individual legal fees and make it even more affordable. So that is something that we are considering doing and working towards that option if we're not seeing action very quickly on these pending I-539s.
Emily, on the Trump has made a lot of announcements with regards to the immigration. He said that he's leaning towards the merit-based immigration. He put a pitch towards the Congress to pass. What is a merit-based immigration? Now, we're going to go into the politics later on, but can you explain what is a merit-based immigration? How is it different than the current immigration that we have?
Yeah, I think he's mainly referring to kind of a points-based system where we set out a certain number of points based on age, based on education, based on income level, English speaking skills, and you can set any different parameters you want with that. And the more of those criteria that you meet, the more points you've earned, and then they'll set a specific cutoff for how many points you need to get in order to qualify for your green card. So I think that's what the plan is. As far as what those different points are, nobody knows. I think everything is kind of just a thought right now. It's very vague. We don't have any details until someone actually puts a proposed bill into play. We won't have any details, but they've given a couple. I don't know if you want to go through what we know so far.
So, of course, they have said that they're going to base on the age of the applicant. They're going to look into the education. They're going to look into the employment probability. They will also look into what is the salary that person is commanding. They will look into, these are some of the things that they said they're going to look into considering. They may even consider having English capability. They may even have a English or civil test to be done so that if the people score higher marks, they might be considered given certain points. These are all the considerations the Trump administration is considering. But as I said, in everything, the devil is in the details. So when the details are being laid out in front of the Congress, we may be able to see a light of what exactly Trump is planning to.
So speaking of those details, what's going to happen to people currently waiting?
Yeah, we have 3 million people who are waiting for the family-based immigration that are waiting in line. They applied, their priority date is not current right now, more than 3 million of them. And then we have about 350,000 people waiting in line for the green card, mostly for EB2 and EB3 and some of the EB1 cases. They are in line. In in the presentation what Trump administration did, they didn't give the details with regards to what is going to happen with these 350,000 people employment-based immigration. Are they going to grant them under the old system? Are they going to consider the new system? Will they give priority to these people? They have not given any details. But mostly when we see any proposed bill on the Congress, we would be expecting some details with regards to what they intend to do for this existing application. Now, the one thing that all politicians agree and all lawyers agree, the entire people agree, is that this immigration system right now that we have is outdated completely. It was done when, probably when the discrimination was allowed in the country. And still today, we do have a per country quota, which is actually, even though there is no discrimination intent in passing that legislation, the effect of that law is that there is a discrimination based on the national origin in the immigration law that they most probably will be rectifying in this one. Now, based on some of the statistics that I have looked into it at this point of time, if there are 100 green cards given every year, Emily, only 12% were been given for the employment-based, which probably will be merit-based green cards, in a sense that it will be considered. 12% of the 100, if 100 green cards are given, only 12 people are given. The Trump administration seems to be wanting to move from 12% to approximately 60% of the green card should be given based on the merits. So it may be very good news if this goes through, because we are definitely expecting national origin base, which is where per country quota will be out, which is good for all those people who are waiting for a long period of time. And for those people who are talented, educated, for doctorate degrees, highly educated, highly commanding salaries, it may be very good for them to get the green card if the Trump administration bill goes through. Now, Emily, having said that, what are the probabilities that this bill will go through?
Well, certainly it's got a long road ahead of it, because we know that the undocumented population, still nothing has been done there. The Trump administration is still focusing on enforcement and border security. There's a lot of, debate about whether E-Verify should be mandatory. There are so many different ideas out there, and with the Senate being Republican controlled and the House being Democrat controlled, I think it's going to be really tough for any kind of compromise to happen, especially election coming around 2020. So I'm not too sure.
Emily, I've been an immigration lawyer in Clinton administration. I've been an immigration lawyer in Bush administration. I've been an immigration lawyer in Obama administration. I'm an immigration lawyer in Trump administration. These kind of proposals that I've seen in every administration, including the Clinton administration, I've been seeing that from past 20 years, nothing got passed out. There is no major immigration legislation that happened in the past 40 years. And the political atmosphere at this point of time doesn't look like the Congress and the Trump administration are in love with each other. It doesn't look like. So at this point of time, if people are planning their lives, because I know you want to plan buying a house, moving, investing, kids, schools. If you're planning all those things, if you are going to depend on these statements made by based on the history of the experience that I have, please don't make any plans based on this. Try to look into what is actually there right now. Try to plan your life accordingly. Don't believe at this. We will inform you as the things go on, but when you're planning your life, your family, your future, don't depend on this proposal that was sent by Trump at this point of time. Emily, now the H-1B lottery has already been selected. You said that you are getting any receipt notices anymore, or you haven't seen? We
received a few yesterday.
Oh, okay.
All from the California Service Center for Advanced Degree Petitions. Those were all dated the 13th, I believe, of May. So I think we're definitely nearing the end. We didn't get anything in the mail today.
Okay. So, Emily, in the H-1B, a lot of people have filed from F-1 visa conversion to H-1B visa. I want to address that particularly. If their H-1B is not selected in the lottery, and if they are in the cap gap, that means that they are allowed to work if their H-1B is selected, and their OPT is expiring between now and October 1st? What are the options that they have?
Well, if the H-1 is not selected, you can continue on your OPT or STEM OPT until it expires, and then you have your 60-day grace period. So one of the options from that point is to continue your studies. You can enroll back in school anytime while your OPT is valid or during that 60-day grace period. Once the 60 days are over, you're not able to do it that easily. You have to exit the country in order to do it. But to stay in the country, it's just a matter of applying to a new school or applying to your existing school, getting the admission, and getting the new I-20 issued by the time your 60-day grace period ends. But on that note, we've talked a lot about day one CPT as being an option. Or from our standpoint, we're telling people it's not an option because we get a lot of questions about that. There was a lot of controversy about it. A lot happened with the University of Farmington fake school and the unlawful presence memo. So still, I think our recommendation would be, if you're going back to school, one of these so-called day one CPT schools is not the route for you. You came here because you wanted to study and have a career here, and these schools could end that because they're not properly authorizing CPT, and USCIS is denying the change of status to H-1B in that situation. So that I don't think is a good option, but you can certainly go back to school. Just avoid those kind of schools.
And if you have option of moving into H-4, you may want to consider into moving into H-4 visa. That you may want to do it immediately though. And Emily, for those people whose H-1B is OPT is expiring from October 1st to April 1st, what are the options there?
Well, then you're looking at potentially a cap-exempt H-1B employer. These are universities or nonprofits that are affiliated with the university or a nonprofit research organization that don't have to file in the lottery. So if you can find an employer that meets those requirements, they can file any time of year and you could join them. That means you're still subject to the cap, so if you want to ever move to a for-profit employer later, you'll have to go through the lottery even though you're technically in H-1B status with one of these cap-exempt organizations, but that's an option if you have a little more time and can be looking for employment with those. Another option, if your company has multiple locations throughout the world, they may be able to send you to one of their locations abroad to work for a year in either a specialized knowledge manager or executive capacity and then bring you back into the U.S. on an L1. That's also an option. We're actually seeing companies popping up in Canada where they will take care of all of the visa paperwork and provide an office for you to work in Canada for your U.S. employer until you can file in the lottery next year. So that's kind of a new business model, I guess.
Emily, previously we have stated in a couple of conference calls and on the YouTube and Facebook that we haven't seen any employment-based immigration applications getting denied without RFE. And now you said that now you started seeing some denials without an RFE. Can you explain those denials?
Yeah, so I think that it's, USCIS normally in the past would send an RFE even if the, the case that you filed, maybe you filed it a year ago and now it's moot for some reason because you've gotten some other status. They might have sent an RFE in that kind of situation before. Now they'll just deny the case saying, well, we know you've gotten this other status so you don't need this, therefore we're denying it. Which somewhat makes sense from an efficiency standpoint, but at the same time, it could create an issue if you are relying on that pending case to show that you were in status prior to getting your new status. So for example, in one case, someone had filed an H-4 renewal quite some time ago and in the meantime received an H-1B change of status approval. USCIS then denied the H-4 renewal without an RFE, stating that you've already changed your status. In order for us to approve this H-4, it should have been filed as a change of status from H-1 to H-4. So it kind of makes sense, but there are other situations where probably an RFE would have helped clear things up a little bit, especially one very common area is if you're filing a change of status to F1 with these ridiculously long processing times. We've mentioned before that especially kids aging out, turning 21, that are no longer eligible for H-4 and are switching to F1, typically because of the long processing time, they're going to be filing these B2 bridge applications. Well, we've seen cases where the F1, when they finally get around to it, without an RFE, just gets denied on the ground that the person didn't maintain their H-4 status the whole time. But had USCIS requested, we could have provided them with those B2 receipt notices to show that they had been filed those bridge applications and were still eligible for the change of status. So I have a feeling we'll start to see more and more of these types of denials without RFE, and they might not always be.
Emily, having said that, have you seen any denials when the consulting company has not sent an end client letter and the contracts, have you seen any denials without RFE?
No.
So if the end client letter is not there, we have not seen any denial as of now.
Yeah, I don't think that's considered a kind of a required document for the initial filing.
Lots of questions from YouTube. One question that came out is that, can I move to Canada on the H-1B? I have an I-140 approval. I'm assuming that your I-140 is approved for more than 6 months. And then can you go outside the country for 1 year and come back on the H-1B without subject to cap? Yes, you can. Once the I-140 is approved, it's more than 6 months. You're not subject to cap anymore if you have already been counted, which you said from past 6 years or more you are on H-1B, so you don't need to be counted again. A question that came out from YouTube is that when can we expect the H-1B litigation that went into Washington, D.C., when can we expect a result? We're expecting immigration to submit their response probably by end of this week or early next week. We may have some insights into that. The judge may rule within 30 days after the brief has been submitted. And this is just a temporary order. It's not a permanent order. So we have to see if he's going to rule in our favor. If he doesn't rule in our favor, then it's going to go to the full hearing, and then we should be, it might take probably 6 months to 1 year before we can hear anything from the court on that. That's just an approximate time that I'm giving you.
Mohan from Facebook wants to know what exactly is H-1B consular processing and when can it be used? So consular processing refers to what you're asking USCIS to do about your status. So if that's typically used when you're outside the country and don't have a way to get into the country, you're going to request that the H-1B petition be approved and the consulate be notified of the approval so you can apply for the H-1B visa stamp and then enter the country in H-1B status. It can also be used for someone who's in the U.S. in another status who knows they plan on traveling while the application to H-1B is pending, and so they're just going to wait outside the U.S. for it to be approved and then get the visa stamped and come back in. For someone who's had an H-1B in the past and has since left the country, if you have not used up your 6-year limit, or if you've used your 6 years but have an approved I-140, any employer could potentially file an H-1B petition in consular processing for you at any time of year. You've already been counted in the cap, and as soon as it's approved, you get your visa stamp and come back to continue your H-1B status.
I have this question from Salai from YouTube. It's a very good question. It's a common question. How should we file the H-4 plus EAD? Should it be filed along with the H-1B? Should it be filed premium processing? Now, this is what I would recommend. Now, I don't know whether it's going to work or not. You guys will be the guinea pigs for me right now. We filed H-1 and H-4 and EAD together. Since March 11th, we have seen 0 H-4 or EAD approvals that we filed on or after March 11th. The H1s are approved, but H4 and EADs are not approved. So now we definitely want people to take a different path that we've been advising before. What we're recommending is to file a H-1B, H-4 and EAD together, but don't file in premium processing. Once you get the fingerprint notices done for the H-4 and wait for 2 weeks after that, and then you convert into premium processing, because by that time the FBI report and the fingerprint checks will come up. They may be able to adjudicate the H-4, H-1B, H-4 and EAD. They may be, they may not be. But what we have seen for sure is that if you're filing the premium processing initially itself, they are not adjudicating together. So this is a different method we are trying, and of course, this Facebook and YouTube is just not that. We are educating you, and you are there to give us a feedback so that we can pass information to ourselves and to other people too. So I would recommend at this point of time to file under the normal processing, all applications together, then wait for the fingerprints to be done, which normally takes about 2 weeks to 3 weeks. And 2 weeks after the fingerprints are done, then you convert into premium processing.
Ramesh from Facebook has a question about rental properties. So he's currently on H-1 and has a house he's renting out, and for liability purposes wants to create an LLC to run the property from there, and wants to know if that could be an issue. The goal is to avoid unauthorized employment by a company that you don't have an H-1B approved for. So it's going to come down to whether you are doing work for your LLC or you're just using it for the liability purposes. So I think maybe one rental house where you're not consistently running around and doing things in the name of the LLC to operate this rental house is probably okay. That again, if you have 10 rental houses and every day you're going to different tenants and you're making the repairs and you're basically running a rental business, maybe that's a little bit different situation, and that could be unauthorized employment.
I have this very technically good questions coming from Mrs. Benedict. Seems to be a lawyer asking the question, but that's fine. Is it safe to travel now since the court has blocked the injection, blocked the August 9th memo? Maybe not. I mean, if you are on the day 1 CPT, the court may have blocked the unlawful presence though. But what we noticed recently is the students who are coming back into the United States who are working on day 1 CPT, we have had a lot of issues at the port of entry because the USCIS have figured out that these people are not coming to study. They're only using the universities for the purpose of working. I'm speaking of the day 1 CPT universities. And we know that there are like 4 or 5 universities in the community that I am in, and everybody knows those university names. And don't assume that the Customs and Border Protection people at the time when you come into the airport, they don't know that university. We all know that. Don't assume that they don't know. They know those universities. So we have noticed a lot of significant problems when people are traveling and coming back. They've been questioned. Some people who have been deported who were trying to come back from India who are going to day one CPT universities. And some of the questions they asked was, where is your university? The guy doesn't know where the university was. So they did send him back. And there are a lot of other times they found out that this person has not been attending schools. They have deported those people. So you may want to consider that whether D1 CPT is a proper thing for you or not.
Prabhu on Facebook wants to know what happens in the event that employer lays off an employee who's on H-1B. What does the employer required to do in order to make that happen? So in the event that the employer terminates an H-1B worker, the employer is required to offer to pay the return transportation to your home country. If they don't do that, that is a violation of the DOL regulations. They can't just fire you and then expect you to fly home on your own. Now, if you are transferring your H-1B to another employer or changing your status while you stay in the U.S., then of course there's no liability for the employer to have to pay to return you to your home country because you're staying here. But if your plan is to return to your home country, the employer is required to pay for that cost of the transportation. They're also required to inform you that they're terminating you. They can't just tell USCIS that they've terminated you and not tell you anything. So they have to actually let you know that you're being terminated, offer to pay the return transportation home, and then they have to inform USCIS that the employment has been terminated. Those three things are the steps an employer has to take in order to terminate an H-1B worker properly.
Vinay has the question, two questions. I'm going to answer those two questions. Does the premium processing attract more RFEs? The answer is clearly no. That is not true. Premium processing by itself does not attract more RFEs. This is a rumor that we have so many times addressed. It is not true that premium processing does not. The other thing is, can she travel while the H-1 transfer is pending? And she has already started working for the transferred H-1B employer. The answer to the question is, if you travel, the transfer application will be considered to be abundant. I would recommend that you do premium processing, get the H-1B, and then make your travel plans. The other option that you have is that you go travel, you have the H-1B done in the consular processing, and then you make the travel plans coming back into the United States. But while it is pending, you cannot go and come back into the United States. That's not a good option at all for you, Vinaya.
Gautami wants to know, what is the actual process for filing litigation, especially for this H-4 delay issue? So typically you're going to get together all of the information about what's going on in your case, when was it filed, what's the receipt number, where was it filed, what service center, exactly how many days it's been pending, when did you get the biometrics done, and then kind of, are there any, I guess, extenuating factors that make it even worse, that the delay is really impacting you. And you get all of that information together, and you're going to work with an attorney who is going to draft a complaint against the government. And then they'll file that complaint with the court. There's going to be a filing fee paid for that to the court, as well as a legal fee paid to the attorney for that. So that complaint is going to spell out how it is that the court has jurisdiction over the case, meaning what law says the court can hear your claim, what your complaint is, what area of law are you filing this lawsuit under, and then what is your kind of prayer for relief. What is it that you want the court to do at the end of the litigation? So that's your lawsuit that's being filed against the government. The government then has 60 days in order to reply to the lawsuit. And if they decide that, hey, this isn't really a case we want to fight, let's just work this out, during those 60 days, they could just work with USCIS to get the case approved, or at least get the case moving. And then the litigation is over at that point, because you got the result that you needed. If they decide that they want to actually fight the litigation, then it moves kind of to this a round of actual briefs that have to be submitted that further explain the different legal arguments and that support your claim, and then potentially a hearing. But all of that is done by the attorney in the litigation.
Emily, I'm going to answer this question from YouTube from Srinivasa, but I want to put you in trouble after I answer that question. What is going to happen with the pending green card applications if the new merit-based green card system is going to be passed in the Congress? We yet don't know the details, Srinivas. We should see the details once the proposed legislation comes onto the floor of the Congress. We will be able to give you more details. Now, here is a troublesome question to you, Emily. Now, just don't try to answer it as a lawyer. Honestly, how much percentage of chances that you see that the Trump administration is going to be passed in the Congress has the way he said it?
Probably less than 1%, I think.
Can you repeat, please?
Yeah, probably less than 1%. I just don't. That by itself, in its current form that he's proposing, I just don't think you can get the support.
I agree with Emily. I'm in the same line. At this point of time, on my heart, I'm telling that I feel that this legislation has less than 1% probability of passing. So if you guys want to plan on that, that's up to you guys.
Renuka has a question. She has an H1 and H4 pending for husband and wife and wants to know if the H4 can travel due to an emergency. So typically we don't recommend travel while an extension is in process. If your I-94, your current I-94 has not expired, you potentially could go out and come back in based on your current H4 while the extension is pending. But the reason we don't recommend it is it's going to create an I-94 number problem for you, because when you filed your extension, you're going to list your current I-94 number, which is the same as what's on your current approval notice, and that's the number that's going to show up on your H-4 extension approval notice on the new one that's pending right now. But when you travel and come back in, CBP is going to give you a different number. Now you're going to have a mismatch that could come up when you're trying to renew your driver's license, when they go to the SAVE system to verify your current legal status. It could come up at the Social Security office. It could come up in E-Verify if you have an EAD. So it creates a lot of issues. So if you have to travel, it may be best to wait for the H1 to be approved before you come back. Go to the consulate, get your H4 stamped based on the newly extended H-1B approval notice, and then come back. That eliminates the I-94 mismatch issue.
I have a question for you. You disappointed me when you answered me before on the Texas Service Center, but anyway, the same question is coming here again, Emily. Is the Texas Service Center, Jeevan is asking this question from YouTube. Whoa, now we got the Texas Service Center open for the H-1B. Can we pick the Texas Service Center? Who can file in Texas Service Center?
Yeah, so USCIS announced yesterday that they will process I-129s at all 4 service centers now. And so Texas has not traditionally done that. But only companies located in Florida and Georgia can file in Texas.
So not the people in Texas can,
right.
companies that are in Texas cannot file.
Yeah, don't get confused. If your company's in Texas, you actually have to file in California. Companies in Florida and Georgia can file in Texas. And one other weird thing with that is companies located in North Carolina and Michigan show up under 2 different service centers at the moment. So we're waiting on clarification from USCIS regarding which one is the proper service center for those 2 states. But unfortunately, Texans cannot file in Texas. Kishore wants to know if you can apply for a new H-4 EAD now, concurrently with an H-1B petition, if you already have an H-4 EAD that's valid until next year with the old petition. Yes, when it's filed along with an H-1, we've not had a problem of them saying you filed too early or it has to be within 120 days. We've never had that come up, but just be aware of the biometrics problem that's causing delays in getting the H-4 EAD when it's filed along with an H-1.
I know, Emily, you do update Immigration Girl with regards to the receipt notices. From the YouTube, Prashant has, Pranusha has the question that his receipt notice is not there yet. Is there still a chance that he might get in? He's in the advanced degree.
I think that over the next couple of days, we'll probably get the last of the receipts. What I would be looking at is, has any update happened in the SEVIS system? If you are a current F1 student, you may check with your DSO on that or check in your own SEVP portal. Otherwise, check with your employer to see if your filing fee checks have been cashed. If that hasn't happened at this point, chances are probably not good that you were most likely not selected. So the receipts that we received yesterday were issued about a week ago, so that's really the only delay that's happening. USCIS is not generating new receipts right now. They're simply mailing out the last of the ones from last week, and depending on how long the post office takes, that may cause things to come over the next few days.
The question that came from YouTube, Narendra, is not clear, but I think so what he's asking is that his perm has been approved and he's filing in the premium processing. How long it's going to take for it to be approved? Once you file the premium processing in the I-140, it takes approximately 15 days to be adjudicated unless an RFE is issued. The question is not clear to me though with regards to, I don't know, you're trying to post it too many times, with regards and maybe are you asking how long the labor certification is valid? before you file an I-140 application, the labor certification is valid for 180 days. You have to file a I-140, whether it's a premium or normal processing, within 180 days after the labor is approved. You need to file the I-140.
Naveen from Facebook has a question. The H-1 transfer has been approved, but the H-4s are still pending because of this biometrics delay. Is there any problem with the H-4s remaining in the U.S. while these applications get processed? What if their visas are expiring soon, or what if their I-94s are expiring soon? So one thing to be aware of is the visa stamp that's in your passport that you got at the consulate is not what determines how long you can stay in the country. The visa stamp is used to enter the U.S., but once you're here, it's your I-94 that determines how long you can stay in the country. So the visa stamp is kind of irrelevant at this point. But if your I-94 is expiring while your H-4 is still pending, you still can remain in the U.S. Once the I-94 is expired, as long as your H-4 extension is pending, you're considered to be in a period of stay authorized by the Attorney General. It's called POSABAG. That means you are legally in the country and you can stay and wait for your approval to come in. Now, it's not exactly the same as being in H-4 status, but you are legally authorized to remain in the U.S. while you wait, and then once your H-4 approval comes in, that puts you back in H-4 status.
I want your attention on this question by Rohit from YouTube, Emily. His I-140 is approved under the EB1C category. His L1A is expiring in January of 2020. What are his options? 7th year is expiring in 2020.
Yeah, unfortunately, there's no extension beyond the 7-year limit, even though you have the I-140 approved. It's not like an H-1B where you can extend beyond the 6-year limit. You may have to take some strategic trips outside the U.S. to be able to recapture additional time on your L1 so that you can extend beyond then to be able to hopefully file your 485, or potentially look at filing an H-1B. Probably should have been considered this year.
Yeah, you should have considered H-1B. Even though you have completed your 7 years of L1, you should have considered the H-1B option. You may, unless you have some other options like H-4, you may want to consider leaving the country. Of course, your priority date and everything will remain as it is. And if you're working for the same company, you have a good chance of coming back on L1. After you leave the country, you stay for 1 full year outside the country, you can come back on L1A. I mean, this is a lot of disturbance from people who have families, who have kids going to school, houses, travel. That's really, but there's not much hope here unless the only hope is if your wife is on H-1B, the H-4 is one of the options. And maybe you should not even apply for student visa because they're rejecting the student visa because you have an I-140 approval. So you'll have to leave the country, most probably.
Naveen has an I-140 that was approved last year and is looking to change employers and wants to know if he has to start the green card process over again with the new employer. So the I-140, as long as it's been approved for 180 days, does remain valid for purposes of filing an H-1 transfer, getting H-1 extensions beyond the 6-year limit. You can keep that priority date, but by the time that you're finally ready to file the 485, yes, a new employer will have to file a new labor and new I-140 for you in order for you to actually file the 485. It doesn't need to be right away, especially if your priority date's nowhere near being current. It doesn't necessarily have to be the first employer that you join. You might join employer B, C, or D, and then 5 years from now, employer D is the one that files your labor and I-140. You port the old priority date, and then when your priority date becomes current, you can file the 485 based on employer D's new I-140.
I'm going to go quickly some of the questions from YouTube. Deal Grabber has a question. H-4 is normal processing has been filed. How many days it takes to get the biometrics? I would say between 2 weeks to 6 weeks is a safe time, Emily.
Yeah.
Biometrics. Another question is that, is it mandatory to respond to the RFE in 90 days? Deepak, it is mandatory to respond to the RFE. Sometimes it may be 87 days, sometimes it's 30 days, depending on, I wouldn't commit to 90 days depending on how many days it is. It's mandatory. If you don't respond to the RFE, most probably, 99.9% of the time, it will be denied because you didn't respond to the RFE. So if you think so that there is no basis or you don't want to respond, I would do one thing, I would go and withdraw the application rather than getting it denied.
Shreya wants to know if the H-4 EAD can be approved if the I-140 has been withdrawn by the employer. As long as that I-140 was approved for 180 days before the withdrawal happened, yes, the H-4 EAD can continue to be applied for based on a withdrawn I-140. A question on SOC code, that's the occupation code used on the labor condition application for H-1Bs, 151121. I believe that's for systems analysts, wanting to know if people are getting requests for evidence or denials because of this code. It definitely increases the chance of a request for evidence on specialty occupation. We don't use it that often anymore. Yeah, it's not easy to get it approved. It doesn't automatically mean your case will be denied. They look at all of the different factors of the job, the occupation code, the job title, the actual job duties, the wage level. All of those are going to be taken into consideration to determine whether to approve or deny an H-1B.
Yojana has this question, H-4 EAD is in progress, can I travel now? Yojana, one thing is that if only H-4 EAD is in pending, you can travel, it will not affect the H-4 EAD. But if you have H-4 plus EAD together filed, then it will affect the EAD and H-4. But just EAD by itself, you can travel, it will not affect your EAD approval.
Sheikh has a question. H-1B was selected in the lottery in regular processing, assuming that dependents filed the change of status to H-4 along with it. He said they've already been done their biometrics, and he wants to know if they'll be approved at the same time. At this point, we don't know. We haven't seen any approvals in regular processing either for those that filed the H-1 and H-4 together, because regular processing for the H-1B is taking at least 4 to 6 months, and this just started in March. So I would hopefully, knock on wood, expect that because by the time USCIS finally gets around to adjudicating the H-1B, the biometrics have well been taken care of, so they should be able to approve everything altogether, but we don't have any actual cases to tell you yes or no. This is new this year.
Madan has this question from YouTube. He's going for stamping for F1. He's an L2 visa. Can he expect some problems? We are noticing a lot of F1s getting denied. The reason is that they're telling that you have an intention to stay on a long-term basis. That's contradictory to the F1 visa, and that's the reason why they're denying it. You may want to consider carefully if ever you even want to move to an F1 visa from L2.
Hanish has a question, filed an H-1 transfer along with an H-4 at the same time and wants to know if the 240-day rules applies and if it applies to the H-4 as well. So first let me say what the 240-day rule is. It is not for transfers, so it does not apply to H-1 transfers. It applies to an extension with the same employer, and it says that once you file an extension with the same employer and it's still pending, and your I-94 has expired, you can keep working for your existing employer for up to 240 days from the date your I-94 expired, in the hopes that within those 240 days your H-1B extension will be approved. It doesn't apply to transfers. Transfers are governed under AC-21, H-1B portability. That says you can keep working for the new employer as long as the transfer is pending, even beyond 240 days. At the same time, there's no 240-day rule for an H-4. So if an H-4 extension has been filed, and the I-94 expires, they fall under that POSA bag, period of stay authorized by the Attorney General that I talked about a little earlier. that says they can stay in the country the entire time the H-4 extension is pending.
Praveen's adjustment of status has been filed. He filed it when the prior date is current. Now he's worried whether his EAD and AP will be approved or it will be denied because the priority dates have moved back. The priority dates moving back will not have any effect whatsoever at all in having your advance parole and EAD approval. However, you asked another question, will it affect your adjustment of status? They will not, and they cannot approve your adjustment of status. It will be pending. It will not be approved, it will be pending. And while it's pending, you can continue extending the EADs and advance paroles. Jitendra has this question. He has applied for L2 EAD. It's been 90 days. Is there a solution that you have? We're noticing that it's taking about 100 to 110 days nowadays for the EAD to be approved. You're coming very close to the solution. I mean, there is no other solution other than requesting the USCIS. And when we spoke with a couple of officers, they said that if it falls in the normal processing time and they get the request for expedited, they actually do the other way around and they delay those cases. So in your case, there's not much options for you other than waiting for your EAD to be approved in 100 to 110 days.
Kunal is, I'm assuming, on F1 status and filed an H-1B in the lottery this year, and he checked his SEVP portal, and it shows that the employment end date has changed from whatever it was before to September 30th, 2019, I'm assuming. So this is a situation for someone whose OPT is expiring sometime between now and before September 30th, and they filed a change of status in the lottery. We're seeing that once USCIS has selected the petition in the lottery, the SEVP portal changes the person's employment end date in the system. And you, as a student, you can log into your own portal and see that end date change. So yes, it is a good indication that you were selected in the lottery. You can ask your DSO to check on their end, and they should be able to tell you that they can see a receipt number or some sort of change of status pending notation in your I-20, so you can double check that way.
Milan has this question. His I-130 has been approved under family-based 1, which is U.S. citizen children that are unmarried and about 21. Now he's married and he has moved to F3, which is married children of the U.S. citizens. Now the USCIS is telling that he can file the adjustment of status even though his priority date is current. Even though his priority date is not current in F3, but it's current in F1. No, you cannot file the adjustment of status because now you fall into the F3 criteria. If the priority date is not current under F3, family-based third petition, you cannot file the adjustment of status. We have noticed sometimes when people call the USCIS and ask the questions, they're not supposed to give you legal answers, and they sometimes do give legal answers. In this case, they've exceeded their authority, I think so, by giving an answer, and that's a wrong answer. You cannot file the adjustment of status when the priority date is not current for you.
VJ from Facebook says his H-1B got selected this year and he has the receipt number, but when he enters it on the USCIS's online case status system at uscis.gov, it says the receipt number is not found. Is this normal or is it a problem? It's totally normal. We started seeing this a lot last year where it just takes time for the online case status system to update. So it doesn't impact the actual processing of the case. It's just the kind of customer-facing database has not been updated. So you may be able to get more information by creating a My USCIS account and entering your receipt number there, and you'll actually be able to see the case status. I will also tell you that even if you are able to see the case number in the USCIS website, it's not updating either. So I mentioned on my blog yesterday that we started seeing approvals and requests for evidence for the CAP cases yesterday. The online case status did not update for most of those. They're still just showing that your case was received. They don't say your case has been approved. They don't say we sent a request for evidence. So the online case status seems to keep getting worse, but try the myuscis.com account.
TD has this question, how long it takes for the H-4 visa person, if the person is in India, to get the stamping. Now, for the people who are in India, and if they're eligible for the H-4, that means they're married, their spouse is an H-1B, you don't need to file any application with the USCIS. The H-1 approval itself with the marriage certificate is enough for you to go for the H-4 stamping. So H-4 stamping depends on how long it takes for the stamping appointment. In the Chennai consulate, it's Chennai and Hyderabad, it's backlog, but Bombay, Delhi are a little bit better, maybe 3 weeks waiting period is there, but you don't need any approval from USCIS. There is nothing they can approve even if they want to. So you just need to take the H-1B and then you're good. This question from the same person whose priority date is backlogged. His priority date is in August of 2018. The present priority date is October of 2017. How long it's going to take to get the priority date to August of 2018. Now, Rohit, here is my answer to me. I have gone 1,000 times, no, more than 1,000 times wrong in predicting the priority date. One more time, I've done more than 1,000 times, I did a mistake in predicting the priority date. Actually, Emily and I tried to explain why are these priority dates? They move forward, they move backward, they move zigzag. I mean, priority date was current in 2007, and priority date was May 2010 for EB2 in 2012. And now it's still not reached that stage. We want to explain, I bought a lot of marbles, different color marbles. We tried to do drama to see if we can explain it. We are still in the process of doing it. Hopefully, maybe by end of this month or early month, we will try to explain why we go wrong so many times in predicting when the priority dates are going to move, how they are going to move. Can you have a better guess than I have, Emily? Are you correct in most of the times?
Yeah, there's just no way to accurately predict it because it's all based on demand, and from one month to the next, one of the problems is we don't really know how many people are actually in the pipeline because the Department of State doesn't have access to all of the I-140 petitions that are with USCIS waiting to file adjustment of status. They only have the consular processing I-140s. And on top of that, how many people have filed EB3 I-140s followed by EB2 I-140s? How many people have filed an I-140 with company A and then moved jobs and now it's company B? How many people were not married at the time when they filed the I-140 and they got married again? How many people upgraded from EB3 to EB2? No data is there in these things too. Yeah, so because of just there's so much uncertainty and it's based on how many people are filing each month. Some people are delaying filing for some reason. It's just impossible to accurately
I did put an article of 108 years to get a green card in February of 2018. You may want to check the stats there, how many people are there with the USCIS, but it's not an accurate, and these are government sites that I'm speaking about. You may also want to check out the Cato Institution. They published an article that it's take 150 years to get the green card if you file right now. They do have some good links in there. It's Cato Institute of on the immigration backlog of the employment base. You may want to check. You may have the statistics there, the links there. Emily, anything else?
I think it's about time to wrap it up for today. So thank you for joining us again. If we didn't get to your question, you can always call our daily conference call. It's free. The number's on our website at rnlawgroup.com as well as the schedule, and one of our attorneys will take your questions and answer those every day. And if you want more detailed information, you can always set up a consultation with us by going to rnlawgroup.com.
Thank you, guys.